Be seated, please. Sorry if I misled people about the session. The next case of the morning is number 21-20138, Willie versus Harris County District Attorney. And we'll hear from Mr. Gerstein. Is Mr. Willie in the courtroom? Just wondered.
Good morning, Your Honor. May it please the Court, I'm Charlie Gerstein for the appellant Andrew Willey. Section 3812 D2B of the Texas Penal Code criminalizes non-commercial speech on the basis of its content. It is therefore subject to strict scrutiny, as all parties to this case concede. And because the district attorney conceded the traditional equitable factors governing the issuance of a preliminary injunction below, the question before this court is whether Section 3812 D2B is likely unconstitutional on the record as it stands. The district attorney offers only three rationales in support of the statute before this court, and based on the record below, none of them can survive the scrutiny.
You might speak a little slower. You're
Forgive me, Your Honor.
So yep, okay, thank you.
Just in a normal pace. This isn't a debate competition.
Okay, thank you very much. My apologies. The first is protecting the attorney-client relationship. And the problem with that interest offered both below and before this court is that it encompasses two potential kinds of communications that Mr. Willey might make. The first is speech to a prospective client, detailing responding to the facts as presented by the client and outlining an accurate, fair, non-misleading legal opinion about the client's.
Well, at a minimum, your client is deliberately interfering with the attorney-client privilege with defendants who have had counsel appointed for them. And at a maximum, he's invading it because he's asking them questions that wherewith he wants to prove his thesis that Mr. Godinich wasn't representing them properly.
I disagree with the contention that he's intentionally or non-intentionally invading attorney-client privilege.
Well, I mean, I don't care what his intention is. That's the impact of it, as reflected in the uncertainty and confusion that the clients exhibited.
I don't think that the clients waive attorney-client privilege by speaking to him because their communications with Mr. Willey are themselves privileged.
Well, it depends on what Mr. Willey's asking them to say, isn't it?
I don't see how Mr. Willey could. He certainly treats all conversations with prospective clients as privileged.
Well, good for him. Well, what have you and Mr. Godinich, has Mr. Godinich asked you anything about the facts? Has he asked you whether there are any witnesses? Has he asked you about your alibi? Has he asked you about your prior criminal record? I mean, if he asks any of that, a client who knew his rights would say that's all subject to attorney-client privilege, because otherwise Mr. Willey could be put on the stand if the client inadvertently, and these criminal defendants are not necessarily schooled in the law, went out and said, well, yeah, I told him this is my third armed robbery and the next time I'm going up for life.
I don't think that's accurate, Your Honor, because they're seeking legal advice, and they reasonably perceive that they're seeking legal advice from Mr. Willey.
He is trying to get them to seek it from him. It's a little bit odd, but I mean, even more problematic in my view, beyond the privilege issue, is the confusion that he's caused. Because the reality is many of these people who need appointed counsel are not, law school graduates. And so they, are perhaps new to the criminal law system. They don't understand what's going on, and they became confused that they'd lost their lawyer and this and that. So why is preventing that not a basis for the ruling that was issued?
Because what a basis for the ruling that was issued or a basis for concluding that the statute is narrowly tailored to a compelling purpose, I think, are two different questions. I think it is not the latter because it's overbroad.
The judgment that was issued, I should say.
It's overbroad relative to that purpose because there are many ways the court can prevent confusion, beginning with explaining to the client's explaining to the defendant, that is, what the defendant's rights are. This instead.
The judge shouldn't have to prepare a client for some random lawyer to show up and start trying to pull them away from their existing lawyer that the judge appointed and the judge thinks was the proper attorney to appoint.
I don't see why that would be the case, Your Honor, because in this circumstance, all the clients are being exposed to is information about what their current attorney is or isn't doing. In fact, not even that, just they are providing that information.
Do you have evidence in the record, or are you just making assertions about the kind of contacts that Mr. Willie had?
The record provides two sources of evidence on that subject. There's two declarations from Mr. Willie and a copy of the representation affidavit that he presented to clients. We do not have, because that would be privileged.
And the representation affidavit said something like, I am not satisfied with my attorney.
That's correct, Your Honor. We don't have any of the responses to those questionnaires because Mr. Willie treats those as privileged. But
why can't the prosecutor go after those responses?
Because they're privileged, Your Honor.
Why are they privileged?
Because they are offered by someone who is speaking to an attorney about a legal matter in which he may seek legal advice. The 22 clients that Mr. Willie communicated...
Not if he's guilty of barratry.
I don't believe that barratry would vitiate the privilege whether he's guilty of it or not, or I have no reason to believe that it would. I think when a client communicates with an attorney about the subject matter that could provide legal advice, that would be privileged. That's uncontested, both below and in this court. The district attorney does not contend that those communications are not privileged. She, in fact, abandoned the argument that she made below that the statute is narrowly tailored to forward the compelling purpose of protecting attorney-client privilege, perhaps for that reason. Mr. Willie, I think, is bound to treat the communications with his prospective clients, all 22 of them that he spoke to, as privileged, and he hasn't revealed any of the information that they've said to anyone other than as directed by the client.
What would be an example of narrow tailoring in order for a state to be able to offer some kind of protection for people who are represented by attorneys from being communicated to by other persons who wish to represent them?
On the basis that the attorneys are seeking money, those prohibitions exist across the board. And for pro bono solicitations, the law in Texas and, to my knowledge, every other state already forbids overreaching communications, misleading communications, communications with anyone who is obviously in a circumstance in which they may feel sort of put upon or compelled to respond, false statements, lies, payment of money to clients, all of the sorts of things that...
Well, suppose it's a 1983 case, and suppose the plaintiff is represented by a civil rights lawyer, and some other civil rights lawyer decides he wants to horn in because he can do a better job. But it can't be pecuniary because he doesn't get any money unless he prevails. And then he goes to the client and says, I don't think so-and-so's doing you a good job. Let's talk about this. What is, do you see what I'm saying?
I think well...
Why can't the law prohibit that?
I don't see what the harm in that communication is. Shouldn't lawyers welcome competition to provide better service?
While they're in the course of representing somebody? I mean, there's too much opportunity for things to get out of hand and get misused, and the privilege, we're assuming Mr. Willie is open and above board, but there are so many other ways to do that without having lawyers frankly besmirch our reputations by going and wheeling in slithering in like, reptiles and saying, well, this guy's not any good. You need to go with me, or you need to go with my friend. I don't care whether it's pecuniary or not. It besmirches the legal profession.
But I think it is at least under-inclusive relative to that purpose, because two things remain true. The moment before the attorney-client relationship is formed in Texas, people are free to solicit as much as they want clients, and the Supreme Court has been clear that that doesn't besmirch the dignity of the profession. In fact, that's a rationale that has been specifically rejected in both the commercial and non-commercial context.
They're not free to just do whatever they want to get clients. I don't agree with that. There are rules about that. But getting back to this point, to me, on top of all of what Judge Jones has asked you about, you have the core issue of your client thinks the judges don't know what they're doing in appointing these lawyers. So we're going beyond simply preserving the merits of attorney relationships. We're also having Mr. Willie think he should substitute himself for the Harris County judges. And that seems to be a much bigger problem to me.
He proposes to move the court for legal relief. I don't think he's in a position to substitute his own judgment for those.
perhaps you're not aware since you're from out of town, but Houston does have a public defender system. The judges in Harris County are not known to be insensitive, nor is the DA insensitive to the needs of indigent defendants. And it seems to me a man like Mr. Willie could be equally religiously motivated to go before the judges and the public defenders and the DA and present his best case. As a criminal defense attorney? Instead of going and interfering with criminal defendants, he could go and make statements to the judges and get them to appoint other people.
Oh, that he could just do that not on behalf of it?
Yeah, he could lobby, in other words, rather than insinuate himself trying to interfere with the attorney-client relationship.
He does also do that, and the fact that there are alternative mechanisms for him to attempt reforms of the Harris County system, I think, is properly relevant, as we cite in our briefs, the Supreme Court's consolidated Edison case. But even if it weren't, the fact remains that the people he is religiously motivated to contact, people he wants to contact, are currently represented by someone that, by their own description and by his, and well supported by empirical data, is handling more cases than he can competently handle. And so if the Harris County District Court disagrees with that contention, it should deny Mr. Willie's motions that he files on their behalf. And if he is unable to support that contention...
But it's okay for him to slow down the criminal process in all of these cases by bringing these motions to the judges, when otherwise his clients might be in and out of bond or jail or whatever?
If he brings a motion that improperly slows down the criminal process, he should be sanctioned for that by the district court.
Well, you're not helping your client's case here.
Well, the district attorney is seeking to preserve the power to prosecute him for speaking with these people. If he presents a claim to the court that's otherwise improper, that's improper for another basis. He can't even communicate with these people. And I think if the issue is that the motions are somehow improper, which no one has contended either below or before this court, and in fact they are not, then the motion should be denied. The way this ought to work, as I see it, is if there are serious claims that an attorney is providing constitutionally ineffective assistance of counsel, the Harris County District Court should hear those claims, and if they disagree with them, they should reject them, and the clients can appeal if they want to, not simply bar the communication because of the prospect that a motion might be unmeritorious and thereby slow down a criminal process.
Not just unmeritorious, but really mess up the indigent defendant. I mean, that's really, to me, the issue. As well, it does seem to me like Mr. Willie is trying to put himself on the bench. And you know, in Texas, you can run for office, so he can run for judge if that's what he wants to do. I'm familiar with that process. But to try to supplant the judge, I don't see how you can say, well, that is allowed by the, First Amendment or whatever.
He doesn't seek First Amendment protection for filing the motions, and of course the court can just deny them, right? So if the court believes
that... He's already gone through and just undone everything that the judge is doing. I mean, it's odd to me to think that he thinks he can replace the judges. I understand what you're saying. He's making a motion. The judge can deny it. But he's stepping in for the judge. He's saying, you are messing up, judge. You're appointing this guy, Godonich or whatever, who is overworked and underpaid, and you shouldn't be doing that, and I'm going to step in and fix your courtroom. Wow. I mean, I was a state civil district judge for 8 years, and I sure saw a lot of lawyers, good and bad, but I don't remember them trying to take my seat.
I mean, I think we disagree with the characterization for the reason you said. Supposing that Mr. Willie is correct, that Mr. Godonich is providing constitutionally ineffective assistance of counsel, and the judge may have no way of knowing that. A lot of these things happen outside the courtroom.
Excuse me, but Mr. Godonich is no stranger as a criminal defense lawyer. He's been appointed in this court in numerous cases. I don't frankly I don't recollect his specific abilities or whatever, but as Judge Haynes says, we're not total blank slates. We know what's going on in the profession. We know what's going on locally. If the man is incapable, I have no doubt that the state public defender in Houston is able to address that.
Your Honor, he doesn't work for the state public defender.
I understand he doesn't, but they have sway with the criminal court judges as to who's capable as a lawyer.
I mean, they may have sway in the sense of they could attempt to persuade the judges outside of court, but they have no control over the appointment.
Well, don't you think they have more influence with the judges than Mr. Willie does, because they're not going in and interfering with other lawyers' cases directly?
That's not in the record, and I don't know about the relationship between
Well,
Mr. Bonin and, excuse me, my time's up. Would you like me to answer that question?
No, you have time for rebuttal. You crammed twice as many words into 20,
Excuse me, Your Honor.
15
Thank
minutes. That's all right. I'm just stating a fact. Ms. Scott? Of course, all this is a rather hypothetical argument, isn't it?
May it please the court, Meagan Scott for the Harris County DA's office. I don't know that we can say it's purely hypothetical. We have the case, Mr. Kermit Johnson, that sort of brought us here today, and the appellant conceded in their complaint that at least 2 of Mr. Godnich's clients, their family members had to reach out to him to find out if he was even still appointed to their case. So I think as far as when we're having a discussion about what confusion this might cause, what delays this might cause in the court proceedings, we have ample evidence that just in the beginnings of Mr. Willey's process, that's already occurred.
I didn't mean that part of it was hypothetical. What I meant was the idea that he'd be criminally prosecuted for barratry as opposed to being, say, brought up before the state bar. That's what I meant, and I realized the law allows this to be litigated. But
So, yes.
What's your response to the issue of interference with the court?
Yeah, so as I said, I think it's clear that we are going to see interference with the court proceedings when this kind of conduct's going on. In Mr. Johnson's case already, there was numerous off-the-record discussions, numerous hearings that had to be had, subpoenas issued, people come in to see what was going on and figure out what had happened. And aside from that, as a broader view, here we have Mr. Willey, who would be presumably filing these motions in however many cases coming in before the court. And, his response in the briefings below as well, and here, that the judge can ultimately decide if this attorney is ineffective, and if they're not, then they'll stay on the case. But part of that is going to require that defense attorney to perhaps defend himself in open court, maybe expose trial strategy to explain why he has or hasn't done these specific tasks on this questionnaire. And ultimately, if the judge decides that counsel has not been ineffective and lets him remain on the case, it's our contention at that point that attorney-client relationship has already been irreparably damaged, because now you've had the defendant in court watching all of this happening, these proceedings, which have not only slowed down his pending criminal case, but then that, there's no really way to tell whether that attorney-client relationship can really move forward with the same level of trust it might have had before.
But I keep thinking, while I don't know that this is a perfect remedy, the defendant always has the remedy of ineffective assistance of counsel should that lead to an improper conviction, et cetera, et cetera. So it's not as if these people are just sitting in a bucket somewhere and being, wrongfully handled and unable to address it.
Absolutely, Your Honor.
As well, if the lawyer is not showing up for hearings and things like that, I'm guessing the judge would, themselves replace them or something like that. If the lawyer is reflecting an inability in front of them, as opposed to doing, as you say, a strategy that maybe looks funny but ends up really being a good one.
Absolutely. So yeah, I think we have protections both pre-conviction and post-conviction. So pre-conviction, this is not happening in a vacuum, right? The judge is able to see how long the case is going on, whether motions are being filed, whether discovery is being handled, whether this case is getting set for trial, what the defense attorney is or isn't doing, and is absolutely within their rights to call counsel up to the bench and say, look, what's going on here? I'm not seeing movement on this case. What are you guys doing? And then post-conviction, we have the whole plethora of ineffective assistance of counsel.
Not to interfere, but the pre-trial, the judge can replace the attorney, right?
Absolutely.
Keep going.
Absolutely. If the judge felt that the attorney was being ineffective, they could replace them pre-conviction. And then we have the ineffective assistance of counsel habeas proceedings that can happen post-conviction, which can also, defend those rights. And the defendant themselves, if for some reason they felt they were not receiving adequate counsel, could raise those issues to the court pre-conviction as well. So it's not an issue where if Mr. Willey is not able to contact these individuals at the jail, that they are going to now be denied their Sixth Amendment rights.
Mr. Gerstein's going to say, all that's super interesting, but the problem is I have the First Amendment right and I'm not getting to use it. So all of the point you just made is nice but irrelevant to me. How do you respond to that?
Right, so if we're going to get to whether or not he should be able to exercise this non-commercial speech right, then we're getting into the compelling state interest of protecting the attorney-client relationship. It's our contention that that is a compelling state interest and that this statute is narrowly tailored to meet that interest. Here we have a situation where the law is only going to prohibit him from interfering with an existing relationship where there's these pending court proceedings, which I think if we look at Primus and Button and United Mine Workers, we end up falling sort of squarely within that framework. When we look at each of those cases, they were all dealing with unrepresented individuals who were being approached for this non-commercial speech. So I think the huge distinction up front with those cases and what we have here is that we're talking about represented individuals who already have pending court proceedings. And if Primus specifically looks to a lack of injurious interference with the attorney-client relationship in that record and cites to that as part of why they held the way they did in that case. And so here, where we clearly would have injurious interference with an attorney-client relationship, I think is a strong distinction between the type of protected non-commercial speech we see in Primus and what the state is looking to prevent here.
The entire landscape of the legal profession has changed a great deal in 50 years since Button, has it not?
It has, Your Honor.
And in fact, Button was pre-Gideon, right?
Yes. So here I think what we're looking at, so this law at issue came into effect in 1993, and the House committee reports, what the legislature was attempting to address at that point was what they called intrusive solicitation. And so that's why I think the important distinction is that represented versus unrepresented, because when we're talking about interfering with an existing attorney-client relationship, then we're going to have the types of harms that those cases were looking at. And specifically, Button looked at the issue of interference with litigation, which I think is the other compelling state interest that we're talking about here. And so what the statute is designed to present is someone going in and sort of putting a wedge between a criminal defendant and their court-appointed attorney. The very fact that those conversations are broached in the way that they are, questioning them about what their defense attorney has or hasn't done, without the benefit of discovery in the case, without the benefit of what trial strategy might have informed defense counsel's decisions to do or not do those specific tasks, is going to sow those seeds of doubt. And so even if we ultimately end up with the trial court deciding to keep that counsel on the case, we've already injured that relationship at that point. And then, not to mention, if we're filing these motions in however many cases, then we're going to be slowing down an already extremely overburdened criminal justice system.
Let me ask you this. I think whichever way we rule, since we're ruling on a preliminary injunction, we'd be remanding the case to the district court. And so tell me about the recusal issue.
Absolutely. So I think the recusal issue, initially there was some confusion because the nonprofit that Mr. Willey works for was also mentioned in those initial pleadings. And so I think Judge Hughes was rightfully confused as to whether this suit was being brought on behalf of Mr. Willey individually or on behalf of the nonprofit. And so in looking into that issue, he stumbles upon this other website, right? Restoring Justice versus Restore Justice, I think, was the difference. But I don't think that any of that raises to the level of what we would need to see.
Do you think Judge Hughes is now clearly understanding that it is a different entity, that it is not the tax mess entity?
I do, Your Honor. I think he both understands that Mr. Willey's actually proceeding on his own behalf in this case rather than on behalf of the nonprofit, which I think is referenced in the record. You know, they were pretty clear to clear that up. And then I think he also now understands the difference, you know, between these two entities. And I think that's why we see at the end of that district court proceeding, he asked Mr. Willey to submit that, what he called non-legalistic statement of, okay, Mr. Willey, you as an individual, tell me exactly what you've done, what you haven't done, what this questionnaire is, what this waiver means, etc.
Well, Willie did not move to disqualify Judge Hughes, right?
He moved to have him recused.
Okay, I couldn't remember. Okay.
Yes.
On what basis?
On the basis that I think that he felt that his discussion to whether restoring justice was defunct or had some sort of improper.
Well, okay, I'll ask Mr. Gerstein. I don't even understand the legal basis. God forbid if every judge could be recused from making misstatements of fact from the bench.
Absolutely, Your Honor. In the misstatements, I think that there's some allegation of, you know, extrajudicial source, but they came from public websites, which are, you know, permissible, obviously, for the court to look at.
Whether or not this means that Judge Hughes should have granted the recusal, I do think, you know, hanging around on websites can have some issues for courts. But that's why I asked, regardless of whether that was a good idea or not, because it ended up in the wrong place, I just wanted to be sure Judge Hughes understood that it's a different entity, that Willie's entity, which I understand is not a party here, but that is his entity or the entity he's part of, is not the one that had the tax issue or whatever it was that concerned Judge Hughes.
I do think that's clear, and I think another important point is because we are here on just the denial of the injunction, it's going to go back down, you know, presumably for more proceedings in which, you know, those types of issues can be more fully vetted. And to bring it back to the issue of the injunction, I think it's also important to point out that what we're looking at is whether Judge Hughes, there was an abuse of discretion on his part. And so obviously it was the appellant's burden to prove that he had met those four factors in order to receive the injunction, and whether, with the record as a whole, it was an abuse of discretion for Judge Hughes to find that he had not. And here I think it's clear that, you know, likelihood of success on the merits is not, it wasn't clearly erroneous for him to find that he would not have that substantial likelihood of success. Mainly because it's been on the books since 1993, and it's narrowly tailored. I think the fact that it's not been challenged up to this point is helpful in proving that we are here narrowly tailored to those specific interests, because they raise in the lower court the issue of, well, someone who is not seeking representation for themselves or others could presumably walk up to someone and say, you know, your attorney is ineffective and I don't like them and they don't do a good job, and then walk away. And that's a harm that we're not addressing. And I think here the reason that our statute stands up to muster is because we're specifically saying that anyone has the right to free speech, right, to say that they do or do not like a certain court-appointed attorney. But when you cross the line from expressing your opinion about a particular attorney who's on the appointment wheel to actually saying, now I want to represent you myself, and I want you to hire me to help you insert myself in this litigation and remove that person, then you're crossing the line that is legitimately within the rights of the state to want to prohibit in looking at the legal profession and what they can and can't do. If your honors have no other questions, I'll give back my time. Thank you.
Very much.
Your Honor, I'd like to address the issue of remand before this court and clarify a few things about our argument regarding reassignment. The question is not whether the information on which Judge Hughes relied is accurate or not. It's that it's irrelevant to the proceedings before the court. The tax compliance of a nonprofit institution, whether or not a party, is not an issue before the court. The court expressed that he was concerned about this, speculated as to why the suit was brought in Mr. Willey's name based on this, then when confronted with the fact that the information was both irrelevant and inaccurate, repeated his concern, said in fact that he remains concerned about the tax compliance of restoring justice based on the fact that the statement on Restoring Justice's website, the correct website, said only that they're eligible to receive
Is that the
deductions.
worst thing you've ever seen a judge do in court?
In my own practice, yes.
You think it is, huh?
Yeah, but I'm relatively inexperienced in practice by that
Okay,
standard.
just
But
wondering.
I assume that if we were to disagree with you and to reject the suggestion that we should order assignment to a different judge, we could, if we wanted to, take the opportunity to make it certain that the information on which he had relied was obviously untrue, and that would be his knowing that would be one of the reasons why we would not then require a reassignment.
the question of reassignment, Your Honor, is assessed, as is the question of recusal, from the perspective of an objective observer of the proceedings. So the question whether or not he subjectively understands that this was a mistake or that it's irrelevant is not the question before this court. The question is whether a third-party observer of these proceedings would question whether Judge Hughes is abusing his discretion in managing the case and in making decisions based on the two factors we identified, that the fact of the search, which again I'd like to emphasize, this information is not easy to find. To an objective observer, it would appear to be the subject of a relatively in-depth search, not a mere perusal for curiosity, because it doesn't appear in early search results. That, again, is uncontested, both before the district court and here. So to an objective observer, what appears to have happened is an in-depth search for negative information about a party that resulted in reliance on that information in court. We certainly don't make the contention either that finding inaccurate facts or merely perusing for curiosity about a party is a basis of either recusal or reassignment, but this, in our view, goes significantly beyond that. And indeed, to address something Judge Haynes says, there is no, as I understand it, there's no question that the case is going to be remanded because this is an interlocutory appeal. And the question before this court is whether, based on the limited record below, the state can carry its burden of showing that this statute can survive strict scrutiny. And as we mentioned in our briefs, they present no evidence that these harms are real, that this is narrowly tailored to prevent them. And I'd cite the court to the Supreme Court's decisions in Florida Bar versus went for it, United States.
You have to show a likelihood of prevailing.
That's correct.
That's your burden.
Yes, that's correct.
Preliminary injunction. So that's what we're assessing in part, among other factors.
Although we do not have to show that we do in fact prevail. That is a matter such that on remand. I'm sorry, Your Honor.
Likelihood still is something more than, gee, I made a good argument.
Yes, of
It
course.
has to be likelihood.
But if there are questions about the facts in the record on remand, the defendant will have the opportunity to present any evidence that she would like to in support of the constitutionality of the statute.
Well, how do you bear your burden?
By showing that the harms that we allege, the harms that they present this statute as a necessary defense of.
What more
are not.
evidence would you be presenting than you already presented?
We are unlikely to present any additional evidence, Your Honor.
Okay, but you bear the burden.
Yes, and we present evidence that Mr. Willie's speech
So
is
we've got your entire case.
You have our entire factual presentation, except insofar as we would present evidence to rebut, for example, the claim that actual confusion occurred in this case. We don't believe that to be the case. We would rebut that contention if presented as a factual matter, and it has not been.
Well, how can there be dispute about that if these clients' relatives were going to I call him Godinich, maybe that's wrong, but going to him and saying, who's representing us? And then the court had to have hearings about it. How would you rebut the confusion issue?
Perhaps they were confused because I pronounce it Godinich, I'm not sure if that's correct.
Well, that's supposedly in the transcript. Or I thought that was uncontested, that's what happened.
But that may be the fact. One of the defendants sent 33 pro se letters to the court. Perhaps he is confused about who's representing him because he never hears from his lawyer. That seems to me the more likely inference to be drawn from the transcript, that he's confused about who's currently representing him because in the course of 3 years.
But if there's more than one inference of fact, don't we defer to the district court on that?
I don't think it's a dispositive fact. Would you like me to answer that question?
But I'm just saying, when you can look at something and think it's A or it's B, then that's what district courts do, not us.
That's correct, but neither party has put on evidence of that.
Okay.
Thank you, Your Honor.
All right, sir, thank you very much. We've taken it under advisement and